Today's topic is the Supreme Court decision regarding buy-sell agreements. Business owners should review their buy-sell agreements with their attorney or other advisors to determine if they're impacted by a new U.S. Supreme Court decision. In a unanimous decision released on June 6, 2024, Justice Thomas ruled in favor of the IRS, holding that life insurance proceeds received by a corporation in order to facilitate the repurchase of a deceased shareholder's stock interest must be included in the value of the corporation for federal estate tax purposes and are not offset by the corporation's obligation to repurchase the deceased shareholder's stock. A prior 11th Circuit Court of Appeals decision, which was the estate of Blount versus the commissioner, held that a corporation's obligation to redeem a deceased shareholder's interest effectively offsets any increase in the value to the corporation from the receipt of life insurance death benefits. The Connelly decision effectively overturns that prior decision. So let's talk about the effect on this with our business owners. You see, business owners with taxable estates or estates that could become taxable must start to weigh this ruling in evaluating whether to utilize a stock redemption arrangement versus a cross-purchase arrangement. The Connolly decision should have no impact on business owners whose business value and their overall estate value is significantly below the federal exemption, which is currently $13,610,000, but scheduled to drop, remember, by 50% in 2026 upon the sunset of the Tax Cuts and Jobs Act. A word of caution here is that there are currently 18 states, including the District of Columbia, that impose a state estate or inheritance tax. In 17 of those jurisdictions, the taxation threshold is lower than the federal amount, sometimes significantly lower. So here's the story of what happened. Michael and Thomas Connolly, brothers, they were shareholders of a building supply corporation. Michael, the decedent in this case, owned 77% of the stock. Thomas owned the remainder, and the corporation held a $3.5 million life insurance policy on Michael's life. Their buy-sell agreement provided for an annual valuation updates, which of course were not done, or as an alternative, a number of appraisals upon death. Instead, Thomas, as the executor of Michael's estate, just entered into an agreement with Michael's son on a $3 million redemption price. Michael's estate included the $3 million value of the redeemed stock interest. The IRS indicated that the value of the corporation was actually increased by the life insurance proceed and was not reduced by the corporation's redemption obligation. The IRS ruled that based on Michael's 77% ownership, his stock should have been valued at $5.3 million. The U.S. Tax Court agreed with the IRS, as did the 8th Circuit Court of Appeals. The question before the Supreme Court was whether the corporation's redemption obligation is a liability that offsets the value of the life insurance death proceeds. They concluded that it is not. Thus, the business value includes the life insurance proceeds without any reduction for the redemption. So here are the typical questions that I'm being asked on this topic. For starters, when is this decision effective? You can expect the IRS and the courts to begin applying this decision immediately. Does this decision only apply to corporations? No. While Connolly involved a corporation, the decision applies regardless of the type of business entity if the entity has the obligation to buy a deceased shareholder's business interest. Does this decision affect the validity of our buy-sell agreement? No. Your agreements are still valid. It affects how the business's value is determined for federal estate tax purposes. It will likely also apply in the 18 states with the estate or inheritance taxes. Your agreement's valuation method still applies, and your obligations under your buy-sell agreement will not change because of this decision. So the next one I hear is, I don't expect to have a taxable estate. Do I need to do anything? Yes. You should discuss the impact of the decision with your legal, tax, and other advisors. Changes in the estate tax law or growth in your estate could really cause your estate to be subject to estate tax. Which leads to the question, does this decision apply only to family-owned businesses? No, It applies to all entity purchase agreements, including those between unrelated owners. Does this decision apply to cross-purchase agreements? No, it applies only to entity purchase agreements. In a cross-purchase agreement, the other owners must buy a deceased owner's interest. The business is not obligated to buy the interest. Would a cross-purchase agreement be a better alternative to a stock redemption agreement? Yes, a cross-purchase agreement would not be impacted by the valuation issue involved in the Connolly decision. Let's do this. If A and B own a $4 million business, they can each own a $2 million life insurance policy on each other to facilitate the purchase of a deceased owner's stock interest. Upon the death of A, B will receive $2 million and will purchase A's stock from A's estate. A's estate tax value is the $2 million redemption price. Since the corporation did not receive any of the death benefit, A's stock value is not impacted by the life insurance death benefit. So then why doesn't everyone just use a cross-purchase? Well, cross-purchase agreements provide a number of benefits over stock redemption agreements, in addition to avoiding the valuation concerns present in the Connolly case. When shareholder B receives the death benefit on shareholder A's life and purchases A's stock from A's estate, shareholder B receives an increase in their basis in the corporation equal to the purchase price that she's just paid for A's stock. There are, however, some drawbacks to cross-purchase agreements. For one, the shareholders must pay the premiums on the policies on each other. Think about this. If I'm a healthy younger shareholder, I might not be too excited about paying the premium on a policy on the life of an older smoker co-shareholder. This type of situation can be addressed by having the business issue a bonus to each shareholder, with the bonus covering the amount of the life insurance premiums required to be paid by each respective shareholder. An alternative would be for the corporation to pay all of the life insurance premiums under a split dollar agreement. All of the policies will still be cross-owned, but they would each be collaterally assigned to the corporation. The corporation owns all of the policy's cash value, which are listed as assets on the corporation's balance sheet. Upon the death of a shareholder, the insurance company would write a check to the corporation equal to the policy's cash value and a second check to the policy owner for the remainder of the death benefit. This arrangement works especially well with what are called wait and see buy-sell agreements. Also, once there are greater than 3 or 4 shareholders, administering a cross-purchase agreement becomes much more complex. In those situations, a trusted cross-purchase or using a partnership or LLC taxed as a partnership to own the policies may be an attractive alternative. So, if a business owner agrees to a cross-purchase agreement, but there are insufficient life insurance proceeds, won't the shareholders be personally liable for the excess buyout price? Well, then consider a wait and see agreement where the shareholders agree personally to purchase the decedent's stock up to the amount of the life insurance death benefit proceeds that were received and leaving the corporation liable for purchasing any remaining unpurchased stock. Does this decision apply to the wait and see arrangements? Possibly. It depends on how the life insurance is owned and whether the business is ultimately the buyer of the deceased owner's interest. 1, life insurance ownership. 2, policies owned by the owners of each other by partnership or by LLC taxed as a partnership will not be included in the business value. 3rd, policies owned by the business will be included in determining the value of the business. 4th, if the business must buy any interest not purchased by the other owners, the business value will not be reduced by that potential liability. Life insurance paid to a partnership or LLC created to facilitate buy-sell planning with a separate business entity will not impact the value of the primary business entity. The primary partnership or LLC entity itself will likely be brought within the scope of the Connolly decision. For example, 4 business associates created an LLC partnership arrangement to facilitate the buy-sell agreement. The entity purchased $5 million of life insurance on each member. Upon the death of member A, the IRS would include the $5 million death benefit in the value of the entity. So does this decision apply to buy-sell agreements funded with term insurance or not funded with any insurance? Yes. The business's obligation to buy is not considered in determining the value, regardless of any funding mechanism in place. What requirements must the value specified in a buy-sell agreement meet for it to apply for estate and gift tax purposes? Well, the tax law disregards the business value set by a buy-sell agreement unless the agreement meets the following requirements. First, the price is fixed and determinable. Second, the agreement must be legally binding during life and at death. Third, the agreement must be bona fide and not testamentary substitutes. If the agreement is between family members, the agreement must meet the following additional requirements. First, the agreement must be a bona fide business arrangement. Second, the agreement must not be a device to transfer interest to the members of the deceased family for less than full consideration. Third, the agreement must be comparable to similar arrangements entered into by persons in an arm's length transaction. So, how do business owners ensure that at least initially they will have sufficient life insurance to meet their buy-sell obligation? Consider consulting with a qualified appraiser prior to the creation of a buy-sell agreement to obtain the suggested valuation methodology language for the type of business involved. Well, there's a lot baked into that discussion. If you have any more questions on this topic, feel free to reach out to me using the contact information at the end of this video.